A person at the jail, please state your name for the record.
James Heady. James Heady.
This is case number 254894 SD. Mr. Heady, you are here on an alleged bond violation that you tested positive for alcohol on December 25th at Community Corrections. If you are found to be in violation of your bond could be revoked. You do have the right to have a contested hearing in this matter, where the prosecution would have to prove to the court that you did in fact violate your bond by testing positive. Mr. Harrison, how are we proceeding today?
My guess is that Mr. Heady is prepared to make an admission, but that may not be correct. The last time I spoke to him, that was his voiced intention.
Mr. Heady, is it your intent to plead guilty to the bond violation today?
Yes.
Or did,
With
right.
reason, if it would have explanation. I did not intend to get
okay,
myself.
hold on. Before we get there, have you had adequate opportunity to discuss that issue with Mr. Harrison?
He had a representative.
Or with another attorney?
Yes.
All right. Has anybody promised you anything in order to get you to plead the violation?
No, I just want to be completely honest because you were so kind the first time we talked.
All right. So then to the allegation that you tested positive for alcohol on December 25th at Community Corrections, how do you plead?
Guilty with explanation by me.
All right. We'll get to the explanation in a minute. Is it true that you had tested positive for alcohol on the 25th of this year or this month, Christmas Day?
Yes.
And had you consumed alcohol prior to
The
testing?
evening before. The evening before.
Right. Okay.
I
So
not unknowing. I knowing I was. If you want explanation, I can explain.
Okay. Go ahead now.
My brother and me were showing up at mom and dad's, and we were having a prime rib that evening, celebrating Christmas. And my brother had brought a platter of pudding cups, I believe they're called, and they're butterscotch. And I knew the punch had alcohol in it because my mother put champagne in it. And I had eaten 3 of those butterscotch because I didn't tell my brother I had been arrested. He didn't know whether to tell. I did not know they were full of vodka. And I had 3 of them, and I see my number the next morning and headed in. I was actually surprised when she told me I tested positive because I didn't recognize what I had done. I didn't have a chance to talk to anybody to figure it out. I laid in jail for 4 days, and I think that had to be it.
Well, it looks like you told Ms. Stark that it was a strong orange juice.
I didn't know because when I'm sitting there talking to Miss Stark, I'm trying to figure out where it came from.
Okay.
I had orange juice for breakfast, and I'm thinking, is it tart? Was that where it came from? Because I was actually mystified.
All right. All right. Well, the court does find that the defendant is in violation of his bond conditions. He was ordered not to consume alcohol and subject to random testing. He did appear. It looks like there was some discrepancy as to when he may have been there originally, but he did appear on the 25th and tested positive for alcohol. So the court does find him in violation. That brings us to what to do with his bond. Mr. Harrison?
Well, Your Honor, given his brief prior history prior to this matter, and giving, I don't know if the court is aware of some of the facts and circumstances surrounding the underlying charge. It was, I don't know how to classify it. In other words, I don't think he is a serious menace to society here. Obviously, this is another perhaps misidentification or mistake on his part. The underlying case involves consumption of a couple of cocktails at a local watering hole, and a short drive later after he was encountered by the officers. despite the fact that he shows a proclivity for using alcohol. It's rather ironic to both he and I, because he's not a heavy user at all. So I would regard this as a blip on the radar, small mistake. He's been otherwise compliant with testing despite the hiccup in the timing on Christmas Day. As far as I know, I would recommend that the court leave his bond where it is. We intend to resolve the underlying matter forthwith, and perhaps we could address any additional sanction or things like that at that point.
Thank you, Ms. Lawrence.
Thank you. I'm gonna leave this one up to the court. I don't know if I necessarily believe everything Mr. Heady is saying that occurred. It is a little bit concerning that the underlying charges is not only operating while intoxicated, but also a high VAC in this case. So that does raise some concern. I am told by Ms. Matsky that other than this incident, he has been doing well on bond. So I will give him credit for that. So I will leave bond up to the court.
Thank you. As Ms. Lawrence pointed out, we've not had any violations with the defendant since he was placed on bond back on the 20th of November. I do find it a little odd that grown people are sitting around doing putting cups or Jello shots, whatever the case may be, and doing multiples of that without knowing that there's alcohol in that. However, the court will continue the bond as previously set. Ms. Matsky, will he need to get signed back up for testing again?
No.
All right.
You'll put it back in the system.
All right. So Mr. Heady, at some point today, you're going to be released and you're back in the testing system. So just make sure that you're checking those numbers. All right.
Thank you very much. I will lay it down.
Thanks, James.
Next arraignment. A person at the Wexford County Jail, can you state your name for the record, please?
Jeremy Powell.
This is case number 255159 FY, the people of the state of Michigan versus Jeremy Joe Powell. Sir, you met with somebody from Community Corrections today and gave them some contact information. Is that information accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the Defender's Office today?
From where?
The Defender's Office?
Yes, sir.
I have a complaint that alleges that on or about December 27th, 2025 in Springville Township of Wexford County, it is alleged in count number 1 that you committed the offense of possession of methamphetamine. That is a felony punishable by up to 10 years and or a fine of $15,000. In count number 2, it's alleged that you committed the offense of possession of a narcotic less than 25 grams. That is a felony punishable by up to 4 years in prison and or a fine of $25,000. Do you understand those charges and the potential penalties?
Yeah. Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I want to hire an attorney, sir.
I'm sorry?
I want to hire an attorney.
You're going to hire your own attorney?
Yes, sir.
You have the financial means to do that?
Yes, sir.
All right. The court will enter a not guilty plea on your behalf and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case will be dismissed. But if they are able to do that, you'll be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, I show in 01 a driving license suspended, 04 NSF check, less than 100. In 05, there was an NSF 100 to 500 set aside. There was a virtual records violation in 05 that's been set aside. In driving the license suspended, second was set aside, and another driving the license suspended was set aside. In the local record, not as CCH, there's a plate violation from 2000, driving the license suspended from 01, an unlawful plate from 04, driving the license suspended from 06. There was a wildlife general violation in 15, set a fire without reasonable precautions, 20 unlawful plate, 94 shining with a bow or a firearm, and in 94 failed to display a license. Mr. Harrison, I know he's indicated that he plans to hire an attorney, but do you have any comment regarding bond? The praxis does score him at a risk level 1.
Indeed, yeah, I'm aware of that as well, Your Honor. In light of that, any concerns the court may have with regard to him possessing or using could be easily allayed through testing. He's a good candidate for PR. He's local. He's been a member of the music community for a number of years. He's employed full-time. He runs his own business for tree removal. I imagine he'll be able to get quite an amount of work done in the next week or so after this latest bout of weather. I don't see any reason to keep him incarcerated at this point. He doesn't appear to be a flight risk. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. This started out as a traffic stop for crossing the center line. Eventually, a clear glass pipe that was filled with methamphetamine, as well as 1 bundle of cocaine, was found on the defendant's person. I do understand he has a very limited criminal history, but given the seriousness of the charges, I am still going to ask for a $5,000 cash surety bond, and I would also ask the court to impose random drug testing.
Thank you. All right, Mr. Powell, as a condition of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testing. I am going to release the defendant on a personal recognizance bond. This does appear to be a first drug violation, at least as he has no prior convictions. Mr. Powell, at some point today, you're going to be released. When you are released, the courthouse is probably going to be closed, so you need to make sure that you present yourself tomorrow to get signed up for testing. Do you understand that?
Yes, sir.
By not doing that, there'll be a violation of the court's order. You could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
Yes, sir.
All right. Next arraignment. A person at the Wexford County Jail, please state your name for the record.
Charles Stuart.
All right, this is case number 255092 OD, the people of the city of Cadillac versus Charles Edwin Stuart. Mr. Stuart, you are here for a bond violation. It's alleged that you failed to enroll in alcohol and drug testing as ordered on December 15th, 2025. You do have a right to have a contested hearing in this matter, where the prosecutor would have to prove to the court that you did in fact violate your bond by failing to enroll. Mr. Harrison, how does your client wish to proceed today?
At this juncture, we would enter a not guilty plea and set it for a hearing. I say that somewhat reluctantly, Your Honor. I've been forced to restart my computer and it's updating, so I can't give you any more details at this juncture, but if you'll give it.
Do you want a moment?
The 20 or so minutes it'll take to update.
Oh, it's gonna be that long. All right. All right, we will set the matter for a contested hearing. Mr. Stewart was originally arraigned on this case back on the 15th of December.
Okay.
With PR bond and drug and alcohol testing, and to enroll with community correction services.
Is the allegation that he simply didn't enroll?
That he did not enroll.
Did not enroll.
So a bench warrant was issued, and here we are today. Comment regarding bond, Mr. Harrison?
I would only say this, Your Honor, due to the time of the year it is and the fact that we have a jumbled up schedule. It will not likely be a couple of days before we can get this resolved. It'll be more like a week or 10 days. In light of that, I would highly recommend that the court release the PR again. And perhaps on this occasion, if he does elect to enroll with testing or clear up whatever the issue is, perhaps the whole thing can just go away.
Thank you. Ms. Lawrence?
Your Honor. I am tempted to ask for a remand for the time being. The defendant has been on bond for roughly 2 weeks now and has still not enrolled in testing as directed. Given the underlying charges, operating while intoxicated, that does cause quite a bit of concern for the people that he has not been testing for the last 2 weeks, and given the holidays coming up, I don't know if I necessarily trust that he is going to follow the direction of the court. So for the time being, I would ask for a remand.
Thank you.
Okay.
Well, as I said, the defendant was placed on bond with personal cognizance bond back on the 15th. It looks like the court signed the warrant in this matter on the 19th, and it was picked up the 26th. So had not tested as he was supposed to for almost 2 weeks, as Ms. Lawrence states. So we will remand until we have a hearing. Next arraignment.